So the next question comes to us from a startup that's wondering how they protect their intellectual property as new hires come on board. And the first starting point is to have some sort of invention agreement. When you hire, you want to make it clear to all the employees that if they do innovate, that innovation is part of their job duties, and that innovation will be owned by the company. And an innovation agreement or invention agreement will state just that, is that everything that they come up with that's related to the business is going to be owned by the business. And that's crucial as you later go to file patent applications. If an inventor leaves, it gives you the ability to make it very clear to the patent office that you, the company, owns that innovation. Another big thing that helps you protect is you should train. You know, every new hire should understand what patenting is about, why you're doing it, what the mechanics are of going about doing it, and how they might participate in your innovation program within the enterprise. Innovation should be part of the DNA of the enterprise, and letting them know that from day one. This is not something that's taught in engineering school, so you have to let them know what it's all about, why they're doing it, and how they participate. The other thing, and it's kind of a reverse problem from the protection problem, is that you also want to make sure that they don't bring in any intellectual property from the prior company. And I've seen this come up in a few different ways. Sometimes there might be a shortcut offered by a new employee in the sense that they have some code already that they've developed. And that code perhaps can be used at this new company. Well, that code came from somewhere, and it probably came from a prior employer, if it's proprietary code, and it's owned by that prior employer. So making it clear that people know that they shouldn't take anything from their old enterprise and embed it into the code or ideas that they might have had at their old enterprise. That sort of thing can come back to bite you because they will likely find out that that code didn't end up in your code, or an idea that was discussed or conceived of at a prior company is now into your product, and then it puts the ownership of that into dispute. So making sure that you know what they're coming in with, and that it's clear to them that they shouldn't really try and capitalize on that at your enterprise. So a lot of companies, when you get hired, they'll ask you to disclose the different things that you've worked on, especially if it was independently, so that it's very clear that that is old stuff and all the new stuff is owned by the enterprise. It sets up a very clear demarcation on the things that the employee came up with while they were employed at your enterprise. So, if you follow those steps, making people aware, getting that invention agreement, you should be in pretty good shape. What happens a lot with startups is the formation is very informal, and the founders often have not gone through that sort of paperwork. So you may have somebody who's very crucial and very involved in the innovation, and that person hasn't signed anything because it was just kind of a group of people, like most startups are, that start doing business, and the paperwork follows. So at some point, getting those invention agreements, even from early founders, is important to go and do just as some basic housekeeping as you clean up the paperwork at the enterprise. So if you go about doing that, you're going to be in pretty good shape. People are going to know what's going on. It's going to be clear that the innovation they came up with at the enterprise is owned by your business, and that and that there's no issues down the line. So, hope that answers the question. In any event, please put any comments or questions, further questions you might have in the comment section below, and we'll get to that question in a follow-up. Thanks.